Welcome to our Thought Leader Series webinar presented by WealthCounsel. Today we have Mary Vandenack leading us through the best practices for preserving testamentary intent in wealth transfers. My name is Monica Comfort and I'll be your moderator today. I'd like to take a couple of minutes to tell you about the valuable benefits of membership in WealthCounsel. You're obviously interested in thought leadership since you're here today. We have lots to offer and continuing legal education that we offer through virtual education, and hopefully someday we'll offer in-person education again. We also offer articles and blogs on timely topics, and all of this is included in your subscription with WealthCounsel. We offer world-class drafting software in Wealth Docs and Business Docs, and we add new content to our software programs regularly, which includes input from our member community. So think of it as having over 4,000 fellow attorneys who can contribute to the value of your document drafting system. And that community helps you build relationships, get helpful answers and advice, network, get referrals, make new connections, and you can share your own experiences. Well, we're also partners with WealthCounsel, the premier community of elder law and special needs attorneys, and you can learn more at eldercounsel.com. Another benefit is our members receive the WealthCounsel Quarterly magazine that covers great topics that you can see some examples of right now, some of our past themes. If you're not a WealthCounsel member yet, you can still subscribe. You need to go to wealthcounsel.com. And right on the home page at the bottom, you'll see a Get It button. You can click that and you'll receive a digital edition of the magazine, which can help you share with your colleagues. While you're on wealthcounsel.com, you can check out the Resource Center tab on the right, to see some of the content that WealthCounsel produces. And under the Education tab, you can check out our education calendar. During today's Thought Leader Series, we will be accepting questions through the Q&A feature in your webinar. And now I'd like to introduce our speaker today. Mary E. Vandenack is the founding and managing member of Vandenack Weaver, LLC in Nebraska. She is the recipient of the 2015 James I. Keene Memorial Award and the honor of Distinguished Women in Legal Tech from the ABA. She is a commentator for Lineberg Services, which is another benefit you get as a member of WealthCounsel. You get access to Lineberg newsletter information services. She has authored, edited, and updated book chapters on trusts for asset protection planning and trusts in divorce after the new Tax Act. Mary, we're very happy to have you here. Thank you.
Thanks very much. So today I'm going to talk about one of my many favorite topics. I was going to say my favorite topics, but almost anything is that, but preserving client testamentary intents. And one of the things I'm actually enjoying about the coronavirus, not that there's a lot to enjoy, but I have seen people take a interest in estate planning in a way that I haven't seen in the past. Well, you see it like when they're getting on a plane to visit North Korea or something like that, and you get that phone call. But I see this at time as kind of an opportunity to really focus on good estate planning practices. So the objectives today are just to talk about testamentary intent. I'm going to talk particularly about, there's a tort called tortious interference recognized in some states, although my best practices are really aimed at kind of whatever the issue might be. We're going to talk specifically about some situations and assets that are particularly vulnerable to where you'll see tortious interference. Talk about some of the best practices. So I'm not going into detail on some of the things I'll touch on, but you can feel free to send a Q&A, or to the extent I don't have time, feel free to email me, and my contact information is later in the slides. The significant thing is there's a huge wealth transfer occurring, and as everybody is aware, there's been significant legislation this year, and there's a big expectation that we're going to see changes to the tax system, particularly the estate tax system. I've sort of given up predicting, but I think there's a huge amount of money that got spent this year, and something will ultimately have to be that the estate tax is set to sunset anyway. I know I'm getting a super high volume of calls of people who are looking to do estate planning strategies this year that they, didn't consider, or were pulling triggers on some of our sort of, we had some strategies in place that were, well, in case the estate tax goes back. I talked to another estate planner in New Jersey recently who said this is kind of like 2012 on steroids so far. So we're going to talk a little bit about testamentary intent and what it is. So testamentary intent is distinguished from testamentary capacity. That's a different issue. Testamentary intent is just simply, what does a person want to have happen when he or she dies? And that can be a whole lot of it. And actually, I go to the thing is, to, what happens when he or she dies, we like to look at that as, sometimes that changes a little. So testamentary intent historically was, what is expressed in your will, but there are other ways to express testamentary intent. That historically, we looked at testamentary intent based on really strict enforcement of formalities. So did we follow the rules? Did we have a will that was written? Did we have 2 witnesses? Did we have a notary, or whatever the requirements of a particular jurisdiction are? And that's been, the case I cite here is one of those cases that said, well, there's good reason, with which I would agree, for some of the strict formalities. But there are some cases recently, or not so recently, that'll make you think twice. So Caspery was a case about a guy who was Jewish, and he'd moved over to the United States, spent most of his time here, got really interested later in life in the Holocaust Museum, and left a significant amount of his wealth to that museum in his will. But based on not completely following the formalities, 2 heirs that he'd had essentially no relationship with came over and tried to challenge his will. And because he had not followed, all the formalities were not exactly in order, then that's, this big gift that he was going to make to the Holocaust was an issue. Similar type of set of facts in Estate of Duke, but different situation. So the guy wrote a will saying basically he, he wanted so much to go to his wife, and he didn't really contemplate. His wife was a lot younger, so it never occurred to him that his wife might predecease him. So it was a certain percentage of the estate is going to my wife, and a certain percentage is going to somebody else. Some heirs came in and said, well, he didn't address predeceased. We obviously didn't mean to give anything to his other beneficiary, which was a charitable beneficiary. And so as a result of that formality, so the California Supreme Court said, this categorical bar on reformation of the unambiguous wills is not justified. Kind of one of the commonalities that I note through these cases that tend to not, let the formalities go by the wayside at least slightly, seem to be where there's a big charitable gift in play as opposed to some other cases. So that would just be the commonality that I'm noting. And with all that said, there's some good reason for formalities. The formalities of wills and trusts right now is interesting in the coronavirus, and I'll talk to that a little bit later. But the formalities can protect testators from fraud, undue influence, and elder abuse. And I've become pretty passionate about that in my practice. The trust and estate litigation, the last time I heard the number was at Huckerling, where I always enjoy meeting WealthCounsel people, by the way. So, but the trust and estate litigation is growing. We've seen that in our practice. And I asked at one point, is that just because I've been around longer? Or is that because I built a reputation, or is there a change? And I think part of the answer to that is it's a little bit of both. So I've become, again, really passionate about saying, okay, when I have a client come in and they're working with me and they're paying me to put their estate in order, part of my role is to really take the steps that I can to help them make sure that what they want to have happen in terms of their assets and structure should actually happen, as opposed to, I'm sure everyone here has had a situation where you spend a fair amount of time planning and then your client dies and everybody comes in and just rearranges things. And there's a lot of flexible procedures, and there's some reasons, and that's not today's topic. But there are actually some reasons for that, but I still think even to the extent we use some of those flexible strategies, that we want them to be in accordance with what the testator really wanted to have happen with their assets. So one of the areas that has been interesting, I say really growing, I don't know if it's growing, it's really been around for a long time, but is what's called tortious interference. If you have over half the states have adopted or acknowledged this tort. One of the big issues with tortious interference is whether or not that tries to supplant probate cases. So there's some cases where a plaintiff will try and use tortious interference instead of an appropriate will contest, and there really is a remedy. There's other cases where there's just really not a remedy in the probate court or will contest, so the tortious interference does seem appropriate in certain cases, and you'll see that come out in the courts in the way that they decide some of the cases. There was a really recent case. Iowa is one of my neighboring states where we have license that has adopted the tort tortious interference. They had a recent case, Youngblood versus Youngblood, which is a really nice case that lays out the whole history of that, and I did provide an outline that summarizes that case as well as most of these. But in that case, the court kind of went through the whole history, and so the restatement second set this out. The restatement third moves away from it a little bit, and if there's really an adequate remedy in probate, the famous Anna Nicole Smith case is one of the cases that's used to say, here's an example of a case where there simply isn't a remedy in the probate court. And in this case, most of you may be familiar with it. Anna Nicole Smith was married for 1 year. The son had promised to leave something to Anna Nicole. There had been a promise, hey, I'll leave you something in my will. That didn't, there was some interference from one of the sons. That went to probate court. Anna filed bankruptcy. The son, it sounds like from the facts of the case, did some pretty egregious things, and ultimately the bankruptcy court said this is an in personam action and there's no real remedy for this in probate court, so we're going to go ahead and hear it here. And that's one of the issues you'll see in the area is sometimes it can be a plaintiff trying to forum shop. Sometimes it's legitimately there's no real use in, there's not really a cause of action in the probate court. So tortious interference with inheritance. So as distinguished a little bit from undue influence and some of the other causes, realize that tortious interference is usually about fraud or duress or some tortious means that somebody prevents somebody from having an inheritance or gift. There are cases where undue influence can actually be used as a basis to determine that there's tortious interference, but as opposed to some of the other causes of actions that are based on maybe lack of testamentary capacity, there's actually an assumption in tortious interference that there is capacity, but there is fraud. The other factors might be a piece of that. So the legal elements of the tort are that the plaintiff had an expectancy that was interfered with. The interference was tortious, so fraud or some other evil action. The defendant would have likely received what was expected, but for the tort, and as a result, there's an actual damage or injury or a loss. So the tort makes sense in cases, there's some cases where testator may have been prevented from actually making a will. The matter involves non-probate assets. So if there's not, everything passes by beneficiary designation, everything passes by transfer on death designations, or perhaps it's a testator who only has life insurance and a couple of contractual assets. Beneficiary would have been a beneficiary under the trust. Defendant caused testator to transfer assets out of estate during life. This is probably the most common one I have seen in my practice, is that there's one beneficiary who will start encouraging a testator to make withdrawals and big gifts or whatever the case might be during life. Again, if the intended beneficiary has no standing in probate court. So some examples of what I'm talking about with tortious interference, and these are either actual cases, in which case I've cited them, or sometimes they're cases that I personally dealt with that may or may not have gotten to court. So if there's not a name on it, I've changed the facts sufficiently to try and keep some anonymity, but to just show kind of the facts. But this is an actual case where decedent had prepared a will. Before death, she wanted to give her house to her niece. The nephew didn't want that to happen. So the nephew said, oh, you're really sick and weak, so, I'll just deed the house to your niece. Don't worry about it. And of course, he didn't do so. So this is an example of action saying, hey, making a promise. not keeping it. She relied on that, and ultimately it was the niece who didn't get it. The niece did pursue this and ultimately won the case and got the house. Another example is insured person agrees to name to the current spouse as beneficiary. And this is one I've actually had where the insured child as POA prevents the change of beneficiary to the current spouse. The other one I've actually had is where some kids who are estranged from their parents show up at the final hour of parents' life and just decide to go ahead and transfer everything to, change the beneficiaries, get themselves named as the POA with the power to change beneficiary and change that to themselves. Another example is somebody who's ill, agrees to transfer real estate, and a second spouse interferes. A really common situation are sometimes the challenges between kids of a first marriage and second spouse, and can be a really ugly situation that we should think about. So I'm talking a bit about the tortious interference, but they do go hand in hand, and especially when I talk about best practices to prevent some of the other types of litigation that you see in this area. So there's will or trust interpretation, the execution issues, and that right now, the best practices about how you execute during the COVID era. I was involved earlier this year in doing best practices for that specifically, and just since we did that early in the pandemic, the rules have changed in a lot of states, so you really have to pay close attention to what's going on in each state in that way. Lack of capacity is a common estate challenge. Undue influence is a common estate challenge. Breach of fiduciary duty, disputed creditor claims, those come up. So this example one is another specific example that I've run into of where you see tortious interference. I earlier gave an example that was actually interference with execution of a will. So I want to point out that interference can happen in relation to testamentary documents, or it can happen in relation to contractual documents. Where we see it most often, and most of the cases talk about, is when there is contractual assets involved, and for a variety of reasons, sometimes those are easier to go, get a change to or not do anything about than a will or a trust document. So this example is one I had where I had basically a daughter took in her mom. There were a couple of siblings that kind of locked mom up into a room. Mom had a bunch of annuities. Really interestingly, mom was 92 and about 80 pounds, but there was $100,000 a year food bill for her, and she owned a Maserati, even though she hadn't driven in like 15 years. That wasn't quite enough, so the daughter was, power of attorney and personal rep, and we just saw the withdrawals come out of annuities. And the really interesting fact in this one is she took withdrawals from the annuities that named her siblings as a beneficiary, and she left the ones that named her as a beneficiary remaining on a tax-deferred basis. So mom got to pay the taxes on those as well. And this another example that I had in my practice was, you start to see this with an aging client. Kid attends meetings with the dad, and in this case, we set up a trust, said assets will be distributed equally among 5 beneficiaries. Dad says, hey, son, will you please use your power of attorney and whatever to get all of these beneficiary designations changed. In this case, the son actually sent some documentation to us as if those changes had been made, but ultimately they didn't get made, and the changes didn't get made, so most of it goes to the son. Another example is when you have, again, first marriage versus somebody else. Daughter gets dad to sign a power of attorney, changes the beneficiary designations to herself or whoever she wants to benefit. There was a case in Iowa where the tortious interference was so egregious that the court said, hey, we're actually going to pay attorney's fees for pursuing this because it was so egregious. This was a case where Mr. Erickson kind of mom was failing over a period of a few years, kept getting worse and worse. The other 2 siblings got worried about the way mom was getting treated, filed for conservatorship and guardianship. the day before the conservatorship and guardianship was to have a hearing, the son, Wayne, got mom to sign off on power of attorney for health care and a legal power of attorney naming him, and then proceeded to take action with reference to her assets that basically kept the other kids from inheriting any of the assets. So they pursued that, and in this case, the court said, these behaviors are so egregious. So this case was in 2018, and this is where sometimes I think that courts will try and get to the right result and use the law in a way that gets that right result. So this was a pretty egregious case. Court said, yes, definitely tortious interference. We're going to pay attorney's fees. 2 years later in Youngblood versus Youngblood, another Iowa case, court saying, looking at it just a little bit differently, saying, well, I don't know about restatement second versus restatement third. So what I suggest to everyone is to just stay on top of the developments in this area, and not just tortious interference, but in undue influence and capacity, because the cases in these areas change on a daily basis, and each jurisdiction has a little bit different rules and a little different take. So if you look at the states that have adopted it, those that haven't, there's a significant variation. But again, you'll see the tendency for most jurisdictions to try and have some way to resolve. Now, I can tell you that my jurisdiction here in Nebraska is it's a state where it's kind of hard to make the case for tortious interference. The Nebraska Supreme Court rejected it, and occasionally there really isn't a remedy in probate court for clients. So continue to look at different ways that you can resolve it. But of course, the best thing is to avoid the lawsuit in the first place, if you can possibly do that, by adopting some best practices to help preserve testamentary intent. So just again, the testamentary intent, just going to repeat that there's a distinction between testamentary intent and testamentary capacity. It's minor, but there is one. But one of those is that the testator, when you do testamentary capacity, you must realize he's actually signing a will, right? That's usually part of it in most jurisdictions. When it comes to testamentary intent, he doesn't necessarily need to know that I am filling out a will. It's just kind of really some kind of clarification about what I want to happen. So various courts have looked at things like language. Somebody wrote in a letter or an email to somebody else saying, hey, if anything happens to me, those little words, if anything happens to me, this is what I want to have happen, can reflect testamentary intent. So a letter to counsel can actually be an evidence of testamentary intent. Being aware of when some of the challenges arise, and I would tell you, so I started with diminished capacity or an otherwise vulnerable client. And a vulnerable client at the end of life, people are particularly vulnerable when they get old and aging. I have an 88-year-old mom, and fortunately she's got 4 of us who look out for her, but that's not the case for everyone. And what I say is sometimes the person in that late portion of life may really consciously choose to give everything to the person who showed up and took care of them at the end of their life. There's a huge value to that. So some people will assume that if there's an end-of-life change of beneficiaries, that of course there had to be undue influence or interference or some evil action to result in that change. And that's not always the case. Sometimes it's really, as somebody says, hey, you know what? My 3 kids, they're okay, maybe. They're off busy with their life. But this person stepped up and took care of me late in my life when it really mattered to me. So the question is, was that really intentional? Is this they really want to take care of this person? And I just will say I've seen a huge, as we have a population where a lot of older people are living on their own with family members who are very far removed from them, might actually choose to benefit somebody who shows up for them later in life. And I see that with one of the big challenges and arguments among children of somebody's like, well, where were you when mom was sick type of thing. And even in my family who, we don't really have any issues, but we'll have conversations, well, hey, I took care of mom for 10 years after dad died, and it's nice that you're showing up now, but And for us, it's kind of a good-natured ribbing, and I hope that's all it is, and that I don't have to see what my siblings are doing differently. But in some families, it becomes venomous. You'll see some of the letters from various people, and I have one client who basically her son's wife married him kind of for what she saw as a pool of money that she was ultimately going to get. My client gets a letter saying, hey, by the way, you're never going to see your grandchildren again unless you write us a check for X amount and agree to do X, Y, and Z. And that client of mine hasn't seen her grandchildren. And one of my tasks is she's basically said, well, I'm not leaving anything to a family member that did that to me. And so trying to document when you have somebody who's the object of the natural bounty type of thing, that you don't make a benefit for, is to establish that testamentary intent so that that will change, or that will structure, trust structure in this case, is what I've done. We want to make sure that that stands up when she passes away. So other places where things occur, I think one of the most common ones is you just have a greedy beneficiary somewhere in the mix, and it can be your client's own kid, it can be a second spouse, it could be, and sometimes it is the caretaker who's just caretaking to try and get as much out of it as they can. Missed asset transfers, so this is partly where we as estate planners can really make a difference. I know in talking to estate planners around the country, there are people look at estate planning as a couple approaches, and the one is kind of, hey, this is a transactional thing. I do an engagement letter, and when I'm done with the estate planning, send out a letter basically terminating the relationship. Personally, I've always looked at my estate planning clients as kind of an annuity who I want to have come back, and most of mine have, and my practice is actually currently closed to new clients because that's just worked for me, and I have a good client base, and I only want to have as many people in my world as I can take care of and take care of really well in the way I like to. But so I do, instead of doing a transactional practice, I look at these as long-term, full-service relationships. And I know there's economics and differences, and that's totally appropriate. I'm just telling you where I'm coming from in the way that I approach estate planning. So I look at, I'm going to try and make sure that we cover as many things as we can. Another area is lack of coordination among advisors, which I speak to, in whole webinars on that, because one of the things I really hate in practice is that you help a client with an estate planning or tax-related situation. They go to see their accountant, and they're like, well, what was Mary thinking about when she did this? And then they go see their insurance guy who's like, what was your account? And they get, it's like the old game of telephone tag. Don't know quite how that works on, cell phones, but there's that whole, they talk to a variety of advisors without having them all in the same room. So I'm really big on coordinating between advisors, and I really encourage my clients to get everybody in the same room, or these days on a Zoom call at least once a year if possible, at least every few years, or find other ways, like to the extent that's a cost issue for the client who doesn't have as much. We have created, we have a process whereby we just send out kind of, as we do an estate plan, we always create a summary of the client at the end of the estate plan. We get a certain period out, we send that out. We always confirm that their advisors are still their current advisors, because we sure don't want to send something out to an advisor who's been terminated. But we try and at least have an annual low-cost coordination with other advisors so that we get that coordination. Another thing is there are dishonest advisors out there, and that's a place where I always try and build into my estate planning cross-checks. This isn't an advisor example, but one of the examples that I had was a 92-year-old lady who was in an assisted living facility. I happened to represent that facility, so I got a call from them because they knew I represented this lady, and they said, we're going to evict your client because she has not paid her rent. And I was like, what? She has plenty of money. That can't be going on. So come to find out, she had turned her affairs over to her son, and she had more than one kid, but she turned over her stuff to her son, who decided that he was going to start paying off his bills, paying off his mortgage, and quit paying mom's assisted living facility rent. So, you know, that's probably one of the worst moments of my life, was going to visit a 92-year-old woman to tell her that she was being evicted from her assisted living facility, which I was able to work out for her. But because her son had spent all her money on other things. And well, that does seem really evil. I did have like a trust officer who said to me, you know, Mary, the thing is, when you name one of your kids as your sole power of attorney or trustee, when they were growing up in your house, you often did just take care of everything. So it's not even necessarily evil intended. I don't think it's right. But at the end of the day, they justify it saying, well, mom would have wanted me to have this. Dad would have wanted me to have this. So that's the kind of thing in estate planning, whether it's kids, advisors, whatever the case might be, that creating some double checks is one of the best practices that I very much encourage these days. That where the best practices start is the due diligence. So we have, you know, what we do is, like, when somebody starts, we want to know a lot of details about them, and we keep it in a really organized format, so that we got, hey, you know, who are you? We have part of our estate planning process is just, we really want to know who you are. And a lot of times what we do is, I'd say what I do is the intake analysis and recommendations is a process where advisors really offer value. So when you start thinking about, I say fees, and alternative fees is one of the things I also speak to, but I actually don't do a flat fee estate plan. I always charge for the intake analysis and recommendations separately, because that's the part of the process I think has a huge amount of value. Is that, hey, I've done hundreds and hundreds of estate plans. I've taken a lot of families through estate processes. And so what's really important is I get to know who you are, what you want, what your objectives are, and then I make you recommendations. And I explain that this is the importance, so that they don't get caught up in, hey, you're just using an automated template to create my estate plan. So I do break out and say, here's part of my value. And I also try and build good relationships with other advisors who can help and support from the beginning of the process. And the financial advisors are often in a really great position to put together information. They've often put together financial information, they've put together profiles, gathered a lot of that information, and can help keep, you know, our time down, but help us do that due diligence. So I always request a financial statement. I always get tax returns from clients. And one of the reasons I request tax returns is that we use this kind of like a forensic asset search. So there's a lot of times, so here in Nebraska, a really common asset to find is somebody, you know, people own oil interests in Texas or Oklahoma, and they've really thought about it in their estate planning context, and they're always the most difficult assets to transition. Sometimes they have some value, often they're not worth anything, and you're spending a huge amount of time. So we pull the tax returns and look at 3 years or even more if we have easy access, just to see if we can find income items that trigger us to ask, you know, are there any assets? We see this, you know, payment, this royalty payment from oil company X out of Texas, just kind of want to know what that was. It helps you kind of uncover some of the assets. Unique assets, clients, you know, I had one lady who came out with a gold bar that she brought out from under the bed after her husband died. Does this have any value? So the question is, are there any assets that we don't have statements for and we need to know about? Marital agreements. One of the biggest malpractice cases I saw in my career was somebody forgetting to ask whether there were any pre or post marital agreements. So we want to know about those, get a copy of those, make sure we know how that affects the estate plan as we go forward. Digital assets these days, you've got to ask about those. Insurance coverages. I always get all of their insurance coverages, even if we're not going to make a change to them, just so we have a picture. We've gone to more of a model of gathering as much information as we can about a client and then creating resources for them to have access to that. Contractual assets, so these are the big area that you see the interference with testamentary intent. So one of the ways that you can really help prevent that is making sure that you have their contractual assets and understand them. So I request annuities, life insurance, qualified plans, which are your IRAs, 401ks, 403bs, all of the assets in that nature, but just in that due diligence process, getting not just a list, but verifying. So I always ask, like, just can we get a copy of the most recent statement? is sometimes people will walk in with an insurance policy that's 50 years old and the carrier has changed like 8 times. So tracking that down can be a challenge, and trying to get the beneficiary designation to the right place can be a challenge. So we try and gather that, and we keep internally lists of, insurance company X was once upon a time. We do the same thing with trust departments because there's a lot of change. So in doing your due diligence, considering the methods of transferring assets at death. And the reason I mention this is sometimes what I will see is somebody will take an agency account or some account and retitle into the trust without realizing that there was a transfer on death designation. So as you're doing the due diligence in gathering the asset information, it's like, okay, so how could this asset pass? Could it be a probate, operation of law? You want to look at the joint tenancy by the entirety. To the extent states have tenancy by entirety, it's really important to understand how that works. It's a great asset protection tool, but there are almost equivalent asset protection tools if for some reason that structure doesn't make sense. The contracts, I like to get all of the detailed information on that, but some assets pass by contract, transfers to a trust. So remember that trust is a contract, so if they have any trust, things are titled in trust. Another way it passes. The joint tenancy in common, significantly different meaning to how those transfer upon death. And then assets will pass by TOD or beneficiary designation. So again, part of the point of that is make sure you know what they have, exactly how it's titled, and if there is any kind of beneficiary designation transfer on death currently in place so that isn't overlooked in designing the estate plan. The common contractual assets, life insurance, annuities, qualified retirement plans, most attorneys that I talk to get those, but what I sometimes see overlooked are business-related agreements, especially in closely held businesses. I like to get all of the different agreements. So I want to know what they have for an employment agreement. Is there a potential payout? So physicians, for example, might have a payout of separation pay that we need to think about having a beneficiary designation for me. That changed before I was ready. And then the marital agreements, which I mentioned, incentive compensation plans, is there a payout? So getting the information on those and how they work. And if there's any irrevocable trust, is what I see sometimes is when somebody provides me their financial information, they're either a beneficiary or they've created an irrevocable trust and it's not part of their estate. Let's hope it was correctly done. But you will occasionally find that they just exclude that, and those are all important things that you want to know about. Remember that the contractual transfer usually prevails over will. So in most states, if a client makes a change to what they want to do, but they don't get the beneficiary designation changed, that might be a problem. The beneficiary designation may rule. So that kind of comes to follow through, which I'll speak to you shortly. Some states do have revocation upon divorce statutes. Some states provide a will that can change the beneficiary of a life insurance policy. And I'm glad that there's statutes like that out there. I would still tell you best practice is to get that beneficiary changed. To avoid the issues with testamentary intent, I do what I call objective-based planning. I spend some time with a client where I just say, here's what we're going to do. We're going to talk about what it is that your goals are. And first, from a family member perspective. And there's, no two clients that are same. I have clients with substantial net worth who, want to make sure that their kids all have incentive to work. So I have one client who's decided a certain amount to each of my children, and then we're doing substantial things for charity. Other people want to make sure their aging mother is taken care of, or, a lot of pet trusts out there. So what is it that really matters to you when you die? And this conversation has been probably the most meaningful conversations I've ever had. Have been in the last 6 months. People are going over their objectives in a way and with a passion and a desire to understand what happens in a way that I've never seen. It's always in every recession or major thing going on internationally, or, you had the 9/11, my sister and brother-in-law are survivors of that in New York. Those type of major life events really impact the way people, but this whole thing with the pandemic, I've had, one client want to have 8 Zoom calls before we could sign their actually fairly simple estate plan. So that creates a great opportunity to discuss objectives. I don't always get those 8 meetings, but I make the focus of really, and it's really interesting watching clients. I mean, some of them are like, well, I don't really know. I haven't really thought about that. I document the objectives, and just part of the reason for that is that it can establish intent. Remember, there's a big difference. The attorney letter summarizing or document that summarizes objectives or intent is actually often accepted as evidence of testamentary intent. Well, unsigned draft documents do not. So a lot of courts will say, you send out unsigned draft documents. Those are not evidence of intent, because they didn't get signed. So we can only assume that the client really didn't want to do that. So it's really, common objectives. And I sometimes try not to hand this list to a client, but for the ones really struggling, I will kind of hand this list and say, well, here's some common objectives that clients of mine will consider in designing their estate plan. Just tell me which one of these matter to you, and that'll help start the conversation. So I kind of have a discussion checklist that I keep for my estate planning meetings that goes through these things to help the client sort of identify that. Because sometimes it's a conversation that they really haven't, and a lot of people really don't like to. I always say coming to see the lawyer about an estate plan is like going to see a dentist for a root canal, because it's about money, death, taxes, family, a whole lot of issues that are not always easy to talk to. So so there's the personal objectives. I'm saying give particular attention to financial objectives, but I think personal objectives and financial objectives are both really important, as are any philanthropic objectives or anything else. So they're all important. But what kind of the reason I get to focusing on the financial objectives is a lot of people make a lot of assumptions about the way that assets will flow, and often don't realize if they say in their will that everything goes to my kids, but they've named their spouse as a beneficiary of their retirement, it's not going to get that done. So I try and get really focused on doing them a picture. And I've seen a lot of attorneys create flow charts that are complex and had to be a lot of fun to create a maze. But what I really try and do for a client is say, well, okay, this is kind of what flows through the will. This flows through the beneficiary designation. And let's talk about the dollars that each person gets based on your asset structure right now, so that they really have an idea. So that's, this is an example that I have. I have a family live in the, rural America out here, sort of. Omaha is actually pretty cityish, but we represent a lot of farm clients. So it's really common to have a farm client come in. And I have this with business owners too. Say I want my business to go to my son, and my property in France to go to my daughter, or in this case, it was I want Farm X to go to son John and Farm Y. Well, at the time that we met, both is worth $1 million. But let's say the son John, and this happens a lot here, has a property that's worth $1 million at the time, but it's in the path of development. So a couple of years later, his property is worth $20 million, while the property going to the daughter is still only worth $1 million, because it's up in a part of Nebraska that there's not going to be any development in. So this is making clear that, are you really trying to get property of approximately equal value to each, or are you trying to get Farm X to one and Farm Y to the other? So I really spend some time making sure, because that's not uncommon. And particularly recently, for every reason, I see people wanting to give particular assets. So it's important to be really, really clear. I like to use the flow charts. Again, it's really easy to get carried away with flow charts. I try and make them super simple to show how the assets will flow and where everything ends up. So rather than, I want the flow to be there, and that helps me think through the process to make sure I don't miss anything in helping the client. But the 100-page book, right? You've all seen the 100-page books that clients will walk in with. Very few of them understand that 100-page book. So I try and limit my summaries to a certain number of pages, and I try and keep my flow charts on one page. And that's always easy. But I don't do that by making it super small. I try and do that by making them super simple. And I just explain, this is an oversimplified, if this is where, because explaining how the trust itself, works, which we are all fascinated with, and matters to them, but kind of that end point of how much is each of your beneficiaries going to get based on your current asset value, I think is a really important thing to make sure we're showing clients, so that they understand that what's going on. Communicating objectives. So I'm big about a written summary. So when a client comes in and we have a meeting, I always put that in writing and send it back to them, because there's a lot of times they look at that and go, oh, did I say that in our meeting? That's not what I meant. One of the things I do love about the Zoom era or GoToMeeting or whatever you're using is I do record my meetings, and I often send them off for transcription. There's a couple services. You don't have to do it yourself. You can have almost all your videos transcribed. There's a variety of services. If you want to know one, feel free to just email me, and I'll give you some of the ones that are out there. But I actually transcribe them now. One of the services I use, I had a 3-hour meeting that they transcribed, and they inserted the F word into the conversation like 21 times, and I'm quite sure that word was never used. So they're not all great transcription services, but at the end of the day, it's a nice documentation. I go in, so I have to clean it up when I see things like that, but it's a good documentation of the client objectives. Communicate objectives to other advisors, obviously checking in to make sure that the advisors are still advisors and that the client wants you to do that communication. But I really believe in coordinating with other advisors so that we're all on the same page, all understanding what the client's desires are regarding testamentary intent. The worst thing is to get to a post-death court hearing and have all of the advisors saying different things. So documenting meetings and statements, document the estate plan as it evolves. So if your practice looks more like mine, where you see the client on a regular basis, you continue. We have a master summary of everything about the client. We actually send it out to the client once a year so that we're always touching base with them. And it includes, what their key provisions are and what they should be thinking about if, there's been a change to the law that they should think about. We send a personalized note out there. So we do that at least annually. So the factors that matter is consistency over a period of time. And that the client understood the estate plan. So that's why making the complex simple is really important in what we do. If there's a reason for a change, so for 20 years they were looking out for daughter Y, and suddenly they're doing something different, documenting the reason. Maybe a kid got disabled, maybe the kid that they were going to benefit, huge issues, whatever the case might be, they're estranged. Document the reason for a change, because again, it's not uncommon that people change what they want to do when they're faced with their own mortality. So just making sure we're documenting it. Being proactive with client capacity issues. Just don't ever be in the position of helping a client sign a document when you have exposure to incapacity. There's a whole lot of cases out there where there's been independent counsel and this and that, where there's still a determination that the client didn't have testamentary capacity. So independent counsel in some of those practices don't always get the job done. If I have somebody I really have doubts about to capacity, I have them get a professional involved who, I don't presume that I'm the right person to make a capacity determination. I don't know anything about neuroscience, and I, play amateur psychologist, but I'm not one and I'm not trained in it. So I want the testamentary capacity determination from somebody whose job that is. And if I think there's any risk with an estate, I bring somebody in and just insist upon it. Be super proactive about undue influence. This is one of the really common things we see with the aging or vulnerable client. So if you have somebody bringing somebody to meetings and just kind of staying in control, and they're talking more than the client, have them leave the meeting. I make sure that I'm talking with my client, evaluating capacity and evaluating influence. And I tell you, best efforts, you're not always going to see it. So that's, again, where sometimes coordination with other advisors or somebody else that that might be close to or know the client can be really important. Using a trust protector. Okay, first of all, using a trust protector can be a big risk if we actually pick the wrong trust protector, right? But there's a case, and this one is in Florida, where basically the trust protector was the drafting attorney, amended the trust to clarify testamentary intent. The court accepted the amendment. And again, it was one of those cases where the facts kind of supported what the trust protector did, but the fact was there was a process in place to clarify the testamentary intent of the person who had passed away via the trust protector mechanism. Again, I'm a fan for trust protectors for a long time, but you do have to design protections into the process to make sure you protect against an evil trust protector as well. Will and trust execution, a really interesting conversation right now. And again, I'd happily refer anybody who wants, because the details have changed and evolved. And I was involved in some webinars about all the signing process currently, and those have changed already in a lot of states. I was reading a commentary this morning, so a lot of people will say, hey, just make sure you video, the signature, whether it's, by Zoom video or in person. And I read a really good analysis on the video that said a video is not the end all to protecting testamentary intent. And that, actually went behind the Electronic Wills Act. There's a whole lot of things that people can do. But one of the points this particular commentator made is that when you put somebody on video, you have to consider the possibility that what you've actually done is create fodder for a potential plaintiff. Because, hey, let's say you have an aging client. Maybe the client has Parkinson's, or maybe the client has some other disease that causes tremors or stuttering. And so then your potential plaintiff brings that video into evidence and said, hey, look at this. Can you see, oh, he hesitated when he was asked to name his children. Well, I don't know. Sometimes I forget my son's name. I don't know. There's, then when they do the little memory test, like I'm going to tell you 8 words and I want you to repeat them. It's when you're on video, people do function differently. Not everybody's great on camera. So consider the possibility that your video needs to be flawless and might not be. And I'm not saying don't video, but to this guy's point, the commentator's point, I would say is make sure you're still going through the process of making sure the client understands, who are you would you naturally give your assets to if you're not giving it to your spouse or children? Why is that? Kind of has an understanding of the nature of their assets. So consider in TERROREM clauses and judicial validation processes. The validation stuff is newer and it really merits its own webinar, so I'm not going to spend a lot of time there today other than that you should be aware of them. The in terrorism clauses sometimes are used. There's a recent case that says, hey, an in terrorism clause may not prevent interference cases. So there's pretty strong case law that it will prevent a lot of will contests. There's some, if there's undue influence, maybe not. Interference is enough of a different claim that the interim clause doesn't necessarily guard against that. So you have to be careful not to say, I'm going to put an interim clause in this document and hey, that is the end all, because it's very likely not the end all. And so we need to continue all of the best practices. Best practices on personal effects. Have you ever been involved in a state where the big fight is about the classic car or, I don't know, the Hummel collection or something like that? So I used to think, well, that's kind of silly because I keep telling my mother to give everything away and I've cleaned out my own house. Nobody else has to do it, even though I'm hoping to planning on hanging around for a while if I don't run into COVID. But I like to specifically discuss the distribution of personal effects with clients. I could just hand them the laundry list, say, hey, go fill this out, but I actually like to talk about it. Some of the things I've run into are like artwork where they bought the artwork with, it ends up being held by a tenancy in common. There's a whole area of art law that's really a combination of various other areas of law. One of the things that we've started looking at, there's various services that will provide an online inventory. And historically, I was seeing it used when somebody moved into a senior facility. I've been starting to suggest at least talking about it, and sometimes we do that inventory, and it's part of the estate planning process. It's so easy to put that online. Now, doing it when they're too young and going to change that a whole lot is probably a waste of energy, but for my clients who are a little older, it begins to make some sense to at least consider making a more detailed inventory. I at least want to know, what are the big assets? You have gold bars under your bed. You have, I had one client's house, and I'm not really good at artwork, so I can tell you I didn't know that the statue I almost bumped into and knocked over was worth a couple $1 million. Like, oh, okay, well, we probably care about that in your estate plan, right? So it's kind of finding out about those unique. And there can be I'm in Nebraska, people own hundreds and hundreds of guns. And so I've learned to ask that question and address that as part of the estate plan. Coordinating assets with the estate plan. So again, if you have kind of a transactional hands-off approach, you might not do this, but if you don't participate in coordinating assets or you don't get involved, make sure you let the client know, let them know in the engagement letter, and repeat it at the end of the process. Personally, I provide a very specific list of instructions on how to coordinate, and I do it on an asset-by-asset basis, and I do it and make it as user-friendly as I can. You want to make sure one of the things to do is the contractual assets, make sure we're not using those to avoid testamentary intent. So that's, again, where you've got to look at the flow, the beneficiary designations, make sure you do those right. I follow up with my clients. I actually do, because they go through so much in the estate planning process, that what I want to do is to say, look, we went through a lot. What we're going to do is we're going to meet in 6 months, because this was all a lot. We're just going to make sure you understand your plan, and we're going to verify the asset coordination. So that is, I am big on following up and coordinating to make sure that we got done, including encouraging team members, bringing everybody together. And I'm going to go ahead. I have a few slides left, but I'm just going to go ahead and open it up to questions and answers. So if anybody does want to answer a question, I like to kind of stay on time, and I'm pretty close to the end of my hour. So if you do have a question, feel free to throw it out there. And what do you use to create your flow charts is one of the questions. And I'm just going to tell you that I use various things over the years, and we actually have a flow charting software. I don't remember the name of it, but I'm happy to provide it. But we actually find that you can use Word, PowerPoint, and Excel depending on your skill level. I like to create them personally in Excel. The inventory, I'm a tech geek, so you saw I've created my own automation. So I actually have the ability for clients to send the inventory in over the web, and we can dump that into what is essentially a spreadsheet that sorts their assets. So I do that by type. But so it's an Excel spreadsheet that started, but that we've automated that spreadsheet so that we can create kind of a presentation from that. We actually flow that in through you can do it through our website. 2, we might enter it. We actually have a portal where we can have financial advisors upload information where we can grab details from that. But hey, an Excel spreadsheet works if you don't have the desire to do all the tech that I have. And then there is the question just about whether the slides will be provided. Absolutely, you can have the slides. If you have any questions that I didn't get to today, feel free to email me. I did provide a more detailed outline. Just realized the outline, I think, is 60 pages because I use it to target different presentations, but it gives you some of the background on some of the cases. But feel free to email me or give me a call if you have any follow-up questions. But thanks very much for attending today, and hope you all are finding the opportunities that I am in COVID to improve our estate planning practices. Thank you.
Thank you very much, Mary. And thank you for taking a few questions and getting those in. I wanted to let everyone know we will send out the materials, including the slides and outline, via email tomorrow. If you want to move toward the end slides, we have an attendance verification code we have to share, and I want to make sure we get that in. There it is. So the CLE attendance verification code for states who need additional proof of attendance is lowercase h, uppercase H, D as in Delta, R, and the number 3. So you can just write that down and keep for your records. You don't need to send it to us since you attended this webinar live. Just keep that for your records, and we will send you a certificate of completion in a week or so once we get approvals in and can show you the course number for your state. Any other continuing education questions, you can email cle@wealthcounsel.com. And at the top of this slide, I wanted to mention if you would like to join our community group, which it used to be a listserv, and now it's a community group on our website, you can go to WealthCounsel's website. The address is member.wealthcounsel.com/community-sign-up, and you can fill out the form there to join our open community group. Our CLE information is there, and we have Mary's contact information here. And just a reminder to mark your calendar for our next Thought Leader Series webinar coming up November 17th. Thank you all for joining us today. Don't forget to share the power of thought leadership that you gain through WealthCounsel. You can post your thoughts on Twitter, Facebook, or LinkedIn, and we welcome any questions or inquiries through wealthcounsel.com. Thanks so much and have a wonderful day. Thank you, Mary.
Thank you.